Welcome, everyone. Thank you so much for joining us for today's Lunch and Learn, the Supreme Court case that could end federal climate action. Despite the urgent need for climate action at all levels, the Supreme Court of the United States is reviewing this term whether the Environmental Protection Agency, the EPA, has the authority to regulate carbon dioxide emissions from stationary sources. This case has implications for climate action and for myriad other issues that federal agencies work on behalf of the American people. Here to sort through all of this with us are Doug Lindner, League of Conservation Voters Judiciary and Democracy Advocacy Director, and Anthony Moffa, Associate Professor of Law at the University of Maine School of Law. Thank you so much for joining us today. My name is Kathleen Neal. I am the Director of Policy and Partnerships here at Maine Conservation Voters and Maine Conservation Alliance. Our organizations represent more than 13,000 members and supporters dedicated to protecting Maine's environment and our democracy. MCA does that through education, collaboration, and advocacy, and MCV by influencing public policy, holding politicians accountable, and winning elections. A few technical notes for today. We will hear presentations from each of our speakers and then tackle questions for both of them in the Q&A at the end. You don't have to wait though. You can send questions to me through the chat whenever they occur to you. I'll keep track of the questions and ask them in the Q&A at the end. We do ask that you not message our speakers directly as we want their focus on the presentation, not the chat box. You can message Will Sedlak if you have any technical difficulties and he will help you out. This event is being recorded and the video will be posted on our website later this afternoon, where you can also find recordings of all of our previous Lunch and Learns. Thank you again for joining us. And Anthony, I will turn it over to you to kick things off.
Sure, thanks a lot, Kathleen, and thanks for everyone for joining us here today on Earth Day. It feels very appropriate to have this conversation on this particular day. Let me get my slides going here, and this is a button from the very first Earth Day that I thought was appropriate to start our show with. And I want to begin this discussion with a kind of grounding of the importance of administrative law and the EPA to the protection of the environment in the United States of America. So this chart, this graphic that is on, that you see in front of you is I think an easy way to understand how not just environmental law, but all regulations work, at least at the federal level. And if we think about the Constitution of the United States as our founding document, where the power to govern the people derives from, the Constitution gives power to Congress, as you probably know, to pass laws about many different things. And Congress, through its lawmaking authority, passes laws that give some of their authority to administrative agencies to make rules that tend to be more specific than the laws that Congress passes. So just to give you an example, right, Congress passes many different statutes in environmental law that give to the EPA the authority to make regulations about a variety of topics of concern. And that is, in the first instance, we don't have Congress deciding, how much pollution comes out of a smokestack, right? That's decided by EPA via regulation. And the reason that EPA can do that is because Congress has delegated EPA that authority through a statute, right? And so we can think about the power flowing from the Constitution to Congress, and then from Congress to the agencies to act. And this whole area, at least as it pertains to climate change, what we're going to be talking about today is really about whether and how, when Congress passed the Clean Air Act in the 1970s and amended it a few times since, whether in doing that, Congress gave EPA the authority to regulate greenhouse gas pollution, right? An air pollutant, I think we can all acknowledge that it is one, and even the Supreme Court has acknowledged as such. And so the question that is at the center of all these cases, at least substantively, is whether EPA can regulate greenhouse gases under the Clean Air Act and how they might go about doing that. And in particular, I want to talk about the EPA's attempt to regulate greenhouse gas emissions from power plants, existing power plants, and they attempted to do that during the Obama administration through a section of the Clean Air Act called 111D. And we won't get into the particulars of that section. I don't want to bore you with that. The only important thing to understand here is that that section says that EPA can decide by regulation what the best system of emission reduction is for a particular pollutant in a particular category of sources. And for our purposes today, that pollution that we're talking about is greenhouse gas pollution, and the category of sources we're talking about are power plants. And so that's what EPA was trying to do with what's called the Clean Power Plan during the Obama administration. And those are the regulations that are the subject of this litigation that Kathleen already mentioned. So in 2015, EPA finalized the Clean Power Plan. And immediately upon finalizing those regulations, attempting to control greenhouse gases from power plants, West Virginia and a number of other states filed suit challenging EPA's ability to do that. That suit was in the DC Circuit. And shortly thereafter, while that suit was pending, the Supreme Court stayed the application of the Clean Power Plan regulations themselves. In other words, Supreme Court said, while this case is being decided, the rules can't go into effect. So there was never any control of stationary sources of power plants that this regulation was able to enact, because immediately it was stayed by the United States Supreme Court. And that was 2016. And if you're not remembering 2016 very well, or maybe you want to blank it from your memory for a variety of reasons, right? It was an election year, and the result is that in 2017, we had a change in administration. And in 2017, President Trump signaled his intent to repeal the Clean Power Plan, to take it off the books. And that put the litigation challenging the Clean Power Plan on hold, because the president said, we're not going to do this anymore. So there's no reason to have a litigation. 2019 comes around and Trump follows through on that promise, at least Trump's EPA does. They repeal the Clean Power Plan, taking back all of the rules that the Obama administration tried to put in place for greenhouse gas emissions from power plants, and they replace it with something called the Affordable Clean Energy Rule. And quite predictably, the environmental groups responded by suing the EPA, challenging their ability to do that again. And so that is the scene that's set as President Biden takes office in 2021, right? So we have an Obama era rule that's been repealed by this Trump era rule and replaced by the Trump era rule. In 2021, the United States District Court, or the United States, the Circuit Court of Appeals for the District of Columbia Circuit, strikes down the Trump rule, that the Affordable Clean Energy Rule. And as it does that, EPA says to the court, we're not going to put the Clean Power Plan back into effect. We're going to issue some new rules. Just give us some time to figure out what those are going to be. Like, we intend to rely on maybe on Section 111D again, but the rules that we put forward in 2015 are outdated. They no longer make sense for a lot of reasons we don't need to get into in here. But the important part is that EPA told the court, we don't need those rules anymore. We intend to put new rules in effect, but we don't know what those are yet. And along comes 2022, and the United States Supreme Court gets the case. And the Supreme Court consolidates both of these cases. So by both of these cases, I mean the original case that West Virginia filed challenging the Clean Power Plan, and the later case challenging the Affordable Clean Energy Plan that the environmental groups launched. So both of these cases are coming before the Supreme Court, and the Supreme Court in this consolidated case is deciding whether EPA has the authority under the Clean Air Act, specifically Section 111D, to regulate greenhouse gases from power plants and how they can regulate greenhouse gases from power plants. And so by the time the case reaches the Supreme Court, right, which was it was argued before the Supreme Court just a few months ago, right? Those of us watching it carefully acknowledge that there were sort of 4 potential outcomes. The one that I have highlighted in yellow here is what we would consider in the environmental community a win in this particular case. And that was the court might have decided, and it might still decide because the case is still pending, might have decided that the case was moot because the President Biden and his administration told the court, we don't need these rules anymore, we're going to make new rules. And so the court might have said, well, we'll wait for the new rules to decide this case, which is what, frankly, they should have done. But instead, the court has other options. They could have gotten to the merits of the case. And getting to the merits of the case is these other 3 doors, right? On the far side over here, inside the fence line, would have been a decision by the court to say that the particulars of the rule, the way that EPA was trying to regulate greenhouse gases, was impermissible under the statutory text, right? And I don't want to get too far into the weeds on that. We can get into it on questions if you want. These other 2 doors are about the whole administrative regime writ large, back to the diagram that we looked at the very beginning. If the court goes through the non-delegation door, it would be reviving a very old doctrine that essentially said when Congress gives some power to agencies, when we're on those 2 levels, lower levels of the when we're going from here to here, Congress has to be very specific. And if Congress isn't specific, then we're going to invalidate that transfer of power. That's what non-delegation doctrine was all about. And for a lot of years, for almost 100 years now, it's been accepted in jurisprudence and by scholars and practitioners that the non-delegation doctrine was dead, right? That there was no real limit on how Congress could delegate its authority to agencies. That in recent years has come into question, and one way the Supreme Court could decide this case is to revive that old rule. Another way it could decide the case, which is quite similar, is an administrative law doctrine that has been born of recent years called the major questions doctrine. And the thing to understand about this doctrine is that it doesn't say that Congress has to be specific all the time, but it says when a question is of political or economic significance, then Congress has to be specific if it wants an agency to make a rule about it. And we could see why you could very easily conclude that climate change is of political and economic significance. So these were the options, realistic options, before the court when it heard oral arguments just recently in this case. And before you get your hopes up, having listened to all of the oral argument, this door is done, right? It was dead on arrival almost immediately in the oral argument. We were not going to win this case. So the case became very much about how this case was going to be lost, which of these 3 doors. And just reading the tea leaves, because it hasn't been decided yet, my view is this major questions door, this sort of middle road, is going to be the way that the court decides this case. And the reason for that is, if you listening to the oral arguments, there was not a lot of appetite among the justices for parsing the language of the statute to decide that EPA was going too far with its regulations. The inside the fence line, outside the fence line concept is about whether EPA can tell power plants that to take actions that occur outside of the physical fence around a particular building. In other words, shifting power generation from a coal-fired power plant to a solar panel next door would be outside the fence line in this terminology. And West Virginia and a lot of opponents of EPA's action here contend that that's not acceptable under the statute. And from listening to oral argument, it became relatively clear that the court didn't have a tremendous appetite for that particular line of argumentation. It also became pretty clear that full-scale revival of the non-delegation doctrine and this sort of going back to a world where giving power to Congress giving power to administrative agencies would be more difficult, didn't seem like there was an appetite for that either. But it did sound like there's an appetite for using this major questions doctrine, this new idea, to stop EPA from regulating greenhouse gases unless Congress tells them to do so specifically. And that's where we are right now. We're waiting on a decision. So I'm a bit reading the tea leaves here. I can't tell you exactly what the court's decision is going to mean. But in my view and the view of others, experts who have listened to the argument, this is the door that the court seems to be wanting to go down here. And so there's a lot of implications beyond just climate change that flow from the court choosing to open this door a bit wider. Major questions has so far been used very sparingly and very recently. And the more times the court uses it, the more problems it's going to cause for environmental law and for the administrative state more broadly. I'll end there and pass the mic, and we can get into a bit more detail during questions if that's where we want to go.
Thanks, Anthony. I think as much as I want to get into questions right now, I'm going to be patient and pass it over to Doug, and we'll dig in after we hear from you, Doug.
Thank you, Kathleen. Thank you, Anthony, and thank you, everyone, for being here. It's great to see some familiar names on the Zoom. I do not have a PowerPoint for you, so it's just going to be me talking at you, but I promise we'll have some fun and we will get to questions shortly. I want to thank you, Anthony, for such a great explanation of the legal issues involved in this case and what is likely to come out of it. I want to switch gears a little bit and talk a little bit more about the political context of the court that is about to make this decision and how we got to this point. So first things first, there was a liberal Supreme Court once, but it's been a very, very long time. There's been a conservative majority on the Supreme Court for a little over 50 years, basically since the 1968 presidential election when Richard Nixon was first elected. But even though we've had a conservative majority court for half a century now, the most conservative court in living memory is the one we have right now. Even when Justice Ketanji Brown Jackson, who we're very excited about and we're very happy to support at the League of Conservation Voters, and MCV played such a critical role in that fight as well. But even when Justice Jackson is seated in a few months, she will be succeeding Justice Breyer, a Clinton appointee, and there will still be a 6-3 majority on the court. I should also say Justice Jackson will not participate in this West Virginia decision. This will be made with Justice Breyer's involvement, so it is a 9-justice court, but 6 of those justices are still on the other side. And even though federal judges serve for life, certainly Supreme Court justices do. Justice Breyer has been there for 28 years and is not the longest serving justice. But even though federal judges serve for life, the people have a critical role through the political process in working toward a judiciary that protects our rights to clean air and clean water, to vote and to be equal before the law. And I want to talk about the politics around the Supreme Court's action on climate and especially what you can do about it. So here's how we got here on the political side. 15 years ago in a case called Massachusetts v. EPA, as we know, the Supreme Court heard a question about whether or not the EPA can regulate greenhouse gases. And they said at the time, not only can the EPA regulate greenhouse gases from stationary sources, from existing power plants, but in fact, the Supreme Court back in 2007 said that the EPA must do that. And it was one of the biggest environmental wins in the judiciary ever in the history of environmental law. And in that moment, when that case happened, that was a conservative court, a 5-4 conservative court. And that decision was made by that court on a 5-4 basis with 4 liberals in the majority. But even then, even with that conservative court, they were still able, by that narrow majority, to recognize the science and to allow and to require the EPA to act. But we live in a different world with different politics and a different court since then. And I want to talk a little bit about how we got here. So that's 2007. Fast forward 3 years to 2010. Your Citizens United v. FEC, which is as you know, a major campaign finance decision in which the Supreme Court largely swept away a century of law on campaign finance and about the ability of our legislatures to regulate in support of a politics that works for the people and not just whoever the most deep-pocketed interests are. And because the Supreme Court made that intervention and has remade our campaign finance and money in politics system, we have seen who the deep-pocketed interests are that want to control and influence our politics. And among those, some of the biggest players that we've seen come into that are the fossil fuel industry. So over the last decade since Citizens United, I expect you've heard a lot about a certain family, the Koch brothers, David and Charles Koch. I believe Charles is still with us and David might not be, but that family, the Kochs, who you've heard so much about because they spend huge money in politics. They've spent billions over the last decade. They are major donors to super PACs on the other side. They are major donors to all kinds of influence operations that one family controls, or not controls, that one family funds hundreds of think tanks and university centers all across the country. And they are among, I believe Charles Koch is one of the 10 wealthiest people in the world. They have effectively unlimited funds to use in their influence operations, and they expect a strong return on their investment, not just in terms of policies that they support because they think it'll make the world a better place by their ideology, but in particular, they want a return on their investment by policies that will benefit their business, because the Koch family controls Koch Industries, America's largest privately held oil company. And that is the kind of political actor, the kind of donors that we're seeing intervene in our politics and in our judiciary in order to skew what our government does and what our courts do about our environment, about our democracy, about so many critical issues we care about that fundamentally ask the question of whether we live in a country where our government serves the people or the most powerful special interests. And it continues to be a fight. And so 3 years after Citizens United, after the Supreme Court came for our campaign finance laws, they started coming for our most critical voting rights laws. And in 2013, the court struck at the heart of the Voting Rights Act of 1965. Since then, there have been a number of cases in which the Supreme Court has either refused to get involved in critical threats to democracy or has rolled back the most important protections we have, including repeated attacks on the Voting Rights Act itself. And that is the context in which we get closer to some of the more recent developments on the EPA's ability to regulate greenhouse gases. As Anthony talked about in 2015, the Obama administration put forward the Clean Power Plan, which was supposed to be President Obama's signature environmental action as Congress was unable to pass major climate action during the Obama administration. The EPA then tried to regulate in favor of climate action. And although that regulation, was great and was created, it was upheld. It was held up in the courts. Donald Trump won the election in 2016, as we all know, and got rid of it and tried to create his own version that has since gone away. But as a result, we've been waiting for this climate action that the EPA should have the authority to implement after Maskey EPA, after that 2007 decision. We're still waiting for it. And part of that is the politics, but it isn't just the politics about who controls the EPA, it's also the politics about who controls the United States Supreme Court. So again, in 2016, before that election, before Donald Trump was elected, we're rewinding to February of 2016, Justice Anthony Scalia dies in office. This is during the last year of Barack Obama's term. There were 11 months left in his term. And in a decision without any precedent in American history, the Senate Majority Leader, Republican Mitch McConnell, at the time in 2016, announced maybe 2 or 3 hours after Justice Scalia died that the Republican-controlled Senate would neither hold a hearing nor a vote on any Obama nominee for the Supreme Court on the pretext that they thought that the next president who would be selected by the people in the election of 2016 should pick the next justice. And so President Obama responded to this by nominating a judge who could not have any serious objection to him. Merrick Garland, who is now our Attorney General, was at the time the chief judge of the DC Circuit Court of Appeals, the 10th most powerful judge in America. He had served on the DC Circuit by that point for 20 years. He had been highly respected before. He was a prosecutor who was involved in the Oklahoma City bombing and bringing Timothy McVeigh to justice. There had been for years whispers from the other side that if there were a Democratic Supreme Court nominee during a Republican-controlled Senate, that Merrick Garland would be someone who would have bipartisan support, who would have, clearly qualified, clearly could be a consensus pick. And that was the context in which we went to that nomination. But Mitch McConnell got his way. The Senate allowed that nomination to be pending for longer than any Supreme Court nomination in American history by far. Merrick Garland was nominated when President Obama still had nearly a year left in his term. And that nomination expired with the Obama presidency nearly a year later. And that has had enormous ramifications because, remember, McConnell said that he thought the American people should get a say in who their next justice would be. The American people did not get a say because the winner of the 2016 presidential election lost the popular vote by a greater margin than any winner of a presidential election ever in American history. Trump lost the popular vote by 3 million votes. The prior record for a presidential election winner who lost the popular vote was to lose by 500,000. But Donald Trump became president, and he nominated Neil Gorsuch to that same seat that at the time would determine the balance of power on the court. After Scalia died in early 2016, there were then 4 conservative justices and 4 liberal justices, and whichever president appointed the next justice, be it Garland or a Trump nominee, would determine the direction of the court and determine which side would control it. And it was the first opportunity for a potentially liberal Supreme Court that had happened, again, in half a century. So Trump comes into office, and that same vacancy is still pending that the Republicans had taken for President Obama. And Trump nominates Neil Gorsuch, a judge of the 10th Circuit Court of Appeals, a very conservative judge. And he did not have 60 votes to be confirmed. And so Republicans changed the rules in the Senate such that Supreme Court nominees could be confirmed with a simple majority, and they confirmed Justice Gorsuch. And then, having said previously that a Supreme Court nominee should not be confirmed within, I think it was 10 months of an election in 2016, because that was too close to the election, there was another Supreme Court vacancy in 2018, a midterm election year. Justice Anthony Kennedy decided to retire, and President Trump nominated Brett Kavanaugh, another DC Circuit judge, to fill that vacancy. And Brett Kavanaugh, I think many of us know, had a number of controversies, including about potential sexual assault in his past, including unexplained debts that had been paid by payers who we don't know, including his extremely partisan and hot-headed conduct during his confirmation hearing. But not only was Justice Brett Kavanaugh confirmed to the Supreme Court, he was confirmed within 1 month of the 2018 midterm election, even though McConnell had previously said the reason that the Republican Senate would not consider any Obama nominee in 2016 was that it was too close to an election in February of an election year versus October of an election year in 2018. Then, in 2020, Justice Ruth Bader Ginsburg passes away in late September of that election year, after the first ballots had already gone out, after voters in North Carolina and many other states had started receiving their ballots and voting. And even though that vacancy occurred when people had started voting in the 2020 presidential election, even though President Trump was enormously unpopular, we were in the middle of COVID, even though it was pretty clear which way that election was tilting, or maybe because it was pretty clear which way the election was tilting, the Republican Senate decided once again to confirm a Supreme Court nominee in an election year when it was their own party's president nominating that justice. And so Justice Amy Coney Barrett was confirmed 1 week before Election Day in 2020. And as a result of that, we have a 6-3 conservative court. Again, the most conservative court that there has been in living memory. And we're seeing a lot of consequences of that. We're seeing it for our environment. We're seeing it in additional attacks on the Voting Rights Act and refusal to act on partisan gerrymandering in the states, even occasionally meddling in gerrymandering cases in the state when the state courts are perfectly capable of handling them. There are a few justices indicating that they want gerrymandered state legislatures to be able to have enormous power over redistricting and voting rights, even beyond what the state constitutions would give them, something that's never been suggested in any serious way until very recently. But to bring it back to where we started here, this is a court that is pursuing an ideological agenda. And it is a court that was created to pursue an ideological agenda and is serving the interests of the people who created it. The coal companies and their right-wing allies in politics on the bench want to bring us back to a pre-1970s situation when Americans choked on soot, on smog, on toxic pollution, where our rivers were dirty and our planet was warming without limits. And these things are very unpopular. Climate action is popular. Americans want clean air, clean water, and a sustainable future. But the industry doesn't, and their allies in politics and on the bench don't. So this is a threat to our climate, it's a threat to our public health, and it's a threat to the ability of all federal agencies that protect the people from powerful business interests, because as Anthony explained, the most likely outcome for this decision is that it will be decided on what they call the major questions doctrine. And the major questions doctrine is an interesting basis for this, or really any case, because it is not in the Constitution. The Constitution is 230 some odd years old. The major questions doctrine was created out of nothing in the year the movie The Lion King came out. I believe it was 1994. Remember all those AOL free trial CDs? That's how old the major questions doctrine is. It is a creature entirely of the conservative court that we are living with. It is something that is murky enough to be used for the ideological interests of the court's majority and not based on serious principles that dictate policy outcomes outside of their ideological interests. And it is something that has wide-reaching implications even beyond our environment. When we hear folks on the other side talk about wanting smaller government or being able to drown the government in a bathtub because it's shrunk so much, they're never talking about shrinking the Army or the Air Force or the FBI or the Department of Homeland Security or any of the other agencies that look tough on something. It's always about shrinking or kneecapping the agencies that protect the American people from powerful special interests who, in the absence of regulation by a government controlled by its people, will be able to exploit the people because they have that power and they want less democracy because less democracy means more power for themselves. So this is a case that the court should never have taken. There is no case or controversy because the Clean Power Plan is not in effect and the Biden administration has not created a new one. There's no reason for a sweeping ruling because of those things and because the proper outcome is clear. The court should never have been involved. There is no case for them to hear. And by the way, the problem of there being no case for them to hear is supposed to be one of the principal limitations on their power. The United States Supreme Court is one of the most powerful courts in the world. They have more influence over public policy than any court in any other major democracy. And yet, one of the few things they're supposed to not do is not use their power unless there is an actual case or controversy before them under Article 3 of the Constitution. And yet here they are kind of making one up. And so that's not great. And I think the really important thing to keep in mind here is, even if you are not a lawyer, even if you are not in the weeds on precisely why the court says it makes the decisions it does, even if you're not interested in reading judicial opinions, even good ones from better justices, it's still really important to pay attention to what the courts do for our environment, for our democracy, and so many other critical issues we care about, because the courts are a power center. And they are a power center that has been largely captured by the other side. So we talked about how the Supreme Court has a 6-justice conservative majority of the 9. But what we haven't talked about yet today is the fact that 1/3 of the judges on federal courts, 1/3 of them are Trump appointees. These are lifetime appointments. There are judges on the courts, last I checked, from the last 10 presidents, but 1/3 of the seats on those federal courts are filled by Trump appointees, 234. I believe that's similar to the number that President Obama got, even though Obama served 2 terms and won the popular vote both times, and Trump served 1 term, which he didn't win the popular vote. President Biden and Senate Democrats have been doing a great job nominating and confirming judges to those lower courts, especially. I think we are very happy to see Justice Ketanji Brown Jackson confirmed, and we're hopeful that President Biden will get to confirm a few more Supreme Court justices. But those lower courts are really important too, because the vast majority of cases in the federal courts and in the state courts will never reach the United States Supreme Court. Very few do. And the Supreme Court is very important, but making sure that we have good judges on the lower courts is also super important. So there have been 59 Biden nominees confirmed to the federal courts so far, and that's great, but there are 234 Trump appointees. And so Joe Biden is doing Joe Biden is doing a better job picking judicial nominees than any president in American history, including Barack Obama. A majority of Biden's nominees are women, a majority people of color, a majority lawyers who spent their careers fighting for the people and not just the powerful special interests who could afford the most expensive lawyers. And it's really important that we all call our senators and ask them to confirm more Biden judges. If you want to get into the weeds of who they are, I can tell you about some great ones like Nancy Abudu, who's a great voting rights lawyer who's up for a seat on the 11th Circuit Court of Appeals and has her hearing coming up next week. But the big thing is we need to call our senators and tell them to confirm more of President Biden's judicial nominees. And that's both because President Trump got so many confirmed in his 4 years that rebalancing the court is going to take some time, but also because if Democrats lose the Senate in the 2022 midterm, which they very well might, it's a 50-50 Senate and the midterm is not looking great for the Democrats. If the Republicans take back the majority, they are very likely to grind these confirmations to a halt. So we are about 15 months into President Biden's term, and they've confirmed 59 judges, which is a record. No president in the last 40 years has gotten that many judges confirmed by this point in his presidency. But it's still not proportional. It's 25% as many judges as Trump got, and we're more than 25% of the way into Trump's term. But also, if the Republicans take back the Senate, they're going to stop confirming judges. Only about 22 judges were confirmed in the last 2 years of the Obama administration when Republicans controlled the Senate, and I would expect even fewer than that to be confirmed if Republicans take back the Senate now. So really important to, number one, call our senators and tell them to confirm more Biden judges all the time, not just this week, but all the time. And number two is to get engaged in the 2022 midterm and try to make sure that we continue to have a pro-environment, pro-democracy United States Congress, state legislature, and local offices going forward. All of these things at every level are super important. And I expect that our friends at Maine Conservation Voters will have plenty of ways for all of us to get involved in this midterm. So I will leave it there and looking forward to getting into questions.
Thank you, Doug. And you're absolutely right. Everybody can be confident that we will share opportunities to get involved in the midterm elections. That is this week's call to action. Absolutely. I also just am so grateful to both of you for helping to educate me for sure about the judicial branch, because I think that there are so many places where it's easy for us to figure out, or we help to make it easy for folks to get involved in the legislative branch and the executive branch. We get a lot of attention to how we make laws in this country and how we set policy. But sometimes the judicial branch can be a bit of a mystery. And so I really appreciate, Anthony, you walking us through administrative law and Doug making those connections about the federal appointments and the judicial appointments that are so important and don't get enough of our attention a lot of the time. I want to go right to questions though, and starting here. So Chief Justice John Roberts once described the role of a judge as someone who calls balls and strikes. Somebody who doesn't pitch, doesn't bat. This doesn't feel completely true anymore. So I'm going to ask each of you, do you think that's still accurate? And if not, is that the ideal that we should be getting back to? How do we do it? You can rock, paper, scissors to see who starts.
Go for it, Anthony.
It may surprise you, or maybe not, to hear this, but I don't think it was ever true. And I think for John Roberts to say that is, for him, an expression of his purported judicial philosophy, or at least his perspective on the courts, but it's not an accurate, it was never an accurate description of the courts. And you can point to some of the cases that both Doug and I have discussed today as examples of that, but there are plenty more. So I think, trying to get back to some idealized world where there's balls and strikes and the rules of the game are set is just not, it's not a realistic goal.
Yeah,
Doug, what do you think?
Yeah, so I 100% agree with that. And I think it's important to think about why it serves people like Chief Justice Roberts to say things like that. Because he's not the only one. Many judges and judges at all points of the ideological spectrum would say that. And I think many of them genuinely aspire to that being their model of judging. But number one, it has never been true. Number two, it has never been less true for, that's a confusing way to put it. The United States Supreme Court is the court for which that is least true. That is the most political of the courts, inherently to its structure. And this is something that's not just a comment on the people who are currently there, but the fact that they are the highest court in the land, the fact that early in our history, they took for themselves the power to strike down laws and actions of the executive branch, the fact that they serve for life, the fact that there are only 9 of them, and the fact that they sit above not only the lower federal courts, but also the state courts, and that they are an independent branch of government, frankly, which itself comes with all kinds of power, it is something that makes it inherently, there are a lot of easy cases that come to courts, and there are some cases that come before a trial judge, for example, in which there is an obvious outcome that any honorable judge from any ideology should reach, which is not to say 100% of them would, but 95% of them would reach the same outcome. And if those cases got to the Supreme Court, frequently there would be a 9-0 outcome in a way that does not follow on predictable political lines. And there are those cases. But the nature of appellate courts, like the US Supreme Court, is that they hear hard cases. And the US Supreme Court in particular not only hears cases in which there is some ambiguity as to what the right outcome should be, but also sits above other appellate courts and gets to choose which cases it wants to hear of the many thousands that come of folks who ask them to hear cases every year. And so by virtue of their structure and of their docket, the United States Supreme Court inherently is going to hear cases in which there is frequently not one obvious outcome dictated by the law. But it is really important to think about why people like John Roberts want you to think that that's what they do, because the power of the judiciary is in the public's and the other branches of government's respect for what they do. The courts don't have armies, they don't have guys with guns. They only are as powerful as the rest of us respect. And it's important for democracy that people follow the law and listen to the courts. But the more the American people believe that the US Supreme Court is apolitical and non-ideological, the easier it is for us to think, oh, we don't need to pay attention. They know what they're doing. We can just leave them alone and not worry about what they're going to do and respect their decisions. And that increases the power of the people who control the court. The more respect that we have and the more that we assume that the Supreme Court is acting in good faith, the less we will engage and try to influence what they do. And the court has been captured. I wish that were not the case. I wish that we could have more respect for the people who are currently there and what they do, but we do need to get engaged because they are not just calling balls and strikes. They're pursuing the agenda that they were appointed to pursue.
If I'm gonna can I just continue the analogy for a second?
Definitely.
Yeah, so I think getting back to the baseball analogy, anyone who watches baseball knows that different umpires have different strike zones, right? So to suggest that there's any objective balls and strikes, and Doug is right. Yes, a fastball right down the middle is a strike for 99% of umpires. Like, those are the easy calls. Those are not the ones that come before the Supreme Court. The ones that come before the Supreme Court is like a slider at the knees on the corner, right? It's okay, maybe that's a strike, maybe it's a ball, and it depends on who the umpire is. And I don't think saying that necessarily questions the legitimacy of the rule of law. What is important is that we stay within the language of the game and the rules of the broader game. And so when you have umpires who are starting to call touchdown rather than ball or strike, right, then you've gone way too far afield, or changing the rules completely, saying some batters get 4 strikes, then you have issues. But so that's where I think you can start to see the sort of the creeping nature of that in recent years, but I wouldn't go so far as to suggest that the rule of law itself has lost legitimacy.
I gotta say, there's probably such a thing as taking an analogy too far. We didn't do that. This is so helpful. I'm like mind blown, really interesting. And this is where the, that question of who is served by by a statement or a description of the work that has never been accurate is really interesting and provocative. And so, Doug, I want to ask you another question, which is there such a thing as nonpartisan advocacy around the court? Is there, is judicial advocacy ever nonpartisan, or is it always partisan to some extent, or some other option on that spectrum?
Yeah, so I mean, there are a few different ways to interpret that. So what do we mean by judicial advocacy? And one thing you might mean is the cases that come before the courts. Most cases that come before the United States Supreme Court, lower federal courts, state courts, any courts, are not politically controversial in the way we usually think about it. There might be some people who disagree with them or who have strong feelings about the outcome, but that cases that would not necessarily follow along predictable partisan lines and, have people on MSNBC saying one thing and Fox saying the other. That's not most lawsuits, even at the US Supreme Court. But in terms of who gets there, appointments to the US Supreme Court have never been more partisan than they are now. And that's true of the lower federal courts too. In the states, it's a little bit different. Different states have different ways of appointing or electing judges. Most states elect judges, which is bad. Y'all in Maine appoint judges, as does my home state of New Hampshire. That is better. And there are some states that have appointments based on stricter merit selection and other ways that can be genuinely less ideological. And there are even some conservative states in the middle of the country that have courts that make decisions you wouldn't necessarily expect that follow the law and that folks of the ideological persuasion of some of us might like better than you'd think based on your states. But in terms of the federal courts, it's really unfortunate that we're at this point where these appointments have become so partisan. It's unfortunate for a lot of reasons. And by the way, one of them is that because the legal community, lawyers in general, tend to be pretty liberal, there is a lot of career boosting with a lot of dark money and political connections for the Republicans who get into these pipelines. And so Republican presidents are more likely to appoint unqualified federal judges than Democratic presidents. That's a real phenomenon. The judge who ruled earlier this week that you don't need to wear a mask on planes anymore is a 35-year-old appointee who was held, who the American Bar Association said was unqualified when she was confirmed 2 weeks after the 2020 presidential election. She was a Trump appointee confirmed after he lost, unprecedented in Senate history to do that, but they did a lot of it. In terms of getting to a place where the courts are less partisan, I think, we have had situations like that. We had presidents like Eisenhower who intentionally appointed justices of the other party in order to curry favor with centrists. But the more polarized the country is, the more polarized this process is going to be. And I think, unfortunately, in order to protect the things we care about, in order to protect our environment, our democracy, and our rights to equality before the law, we as broadly speaking, liberals, who I think fair to say many of us believe in our institutions and want them to be healthy, we have to think about it in an ideological way too, because unilateral disarmament is no way to stop harm from coming to you and to the people and issues that you care about. And so as long as the other side, as long as the Koch brothers and the Federalist Society and the Judicial Crisis Network and the many, many big dark money outfits that want pro-business, anti-regulation, culture warrior, right-wing courts, as long as they are looking at it that way, and because they have successfully captured so much of the United States Supreme Court and the lower federal courts, we got to fight back. And I would love to tell you that there is a way to do that depoliticizes the courts, but I think the only thing we can do for now is to make sure that the other side's politics don't drown out the voices of the people, because we are in the majority.
Thank you. I really appreciate, even when I don't necessarily like the conclusion, I appreciate that. And just the reality check of where we are and really how high the stakes are. I am fascinated by this next question, which is, what led you each to this work? Because you're both clearly so passionate about the role of the courts and the role of the judiciary in our lives and in our policy making. How did you get to this spot? Why do you think about these issues? for Anthony, I want to add on the layer of like, what does it look like to teach? You teach at the law school. What does it look like to educate future lawyers about this very complicated world that we find ourselves in?
Sure. Okay. So very quick version of this. I decided I wanted to go to law school specifically because I wanted to protect the environment. After graduating from law school, I worked for the United States Environmental Protection Agency in the General Counsel's office during the Obama administration, during those last few years when we put out the Clean Power Plan. So I was there for a lot of this, which is why this particular topic is kind of hits home for me. And what it is about teaching that I find most fulfilling is one of the things that speaks to me the most about environmental law and environmental challenges as compared to other challenges are their intergenerational scale, and the fact that we what we do today will affect humans that are not even yet born. And so one of the ways I view having an impact, a lasting impact on these issues is to influence the next generation of people doing the work. And so by posting up at an educational institution, I can see successive generations move through. Even now, as I'm starting to see like a completely new generation of law student that was some of whom were I would have not even been close to my peers at any point in my education. So it seems that's what's nice about it for me. It is a rapidly changing space to be teaching in, though, I will say that.
And are your students, I know some of your students, I know some of your former students.
Yeah.
But are they driven by that? I mean, do people enter in with this like administrative law? No. I mean, I didn't either, right? I think those are just the tools that you need to learn to achieve the objectives on the ground objectives that you're hoping to achieve. That's what we work with. Drilling it into them that they need to understand this stuff can sometimes be an uphill battle. But once they get into practice, I think they appreciate that more so maybe even than in the classroom. But not at all. That is a good question. They're not coming in clamoring to learn about Chevron deference and administrative law and the non-delegation doctrine. That has to be explained as to why that's important. Well, and this is why we are all lucky that you are so good at your work. So thank you. Doug, how about you? What's your story? How did you end up here? And why does LCV care about the judiciary?
Yeah, so, well, first, LCV cares about the judiciary because the judiciary has such enormous power over our environment and our democracy, and those are LCV's core issues. And seeing cases like this, like West Virginia v. EPA, I think really vindicates whoever it was at LCV who initially decided to create this workflow before I started on staff. In terms of how I got here, I am from Manchester, New Hampshire, where, as y'all as New Englanders know, presidential politics is kind of in the water there. And so I was involved at a pretty young age, and I have always looked at democracy and our environment as the two things that, among many super important issues, those two are issues that if our generation doesn't address the challenges we face, not only will it be too late for us and our contemporaries, it'll be too late for the next generation to address these things because they will lose the opportunities that we now have to stave off disaster. And so I went to law school knowing that this is what I wanted to do. And since then, I have worked on a lot of different elements of democracy. I have spent most of my career working on voting rights through the political process. I've worked a little bit on digital privacy and a number of other civil rights topics. I have been involved in the environmental movement a bit before I had gotten into this role, but it is the voting rights work that largely took me here because in my current role, I lead LCV's judiciary work and our federal democracy voting rights, campaign finance, all that good stuff. And so that was largely how I got into it. But I will say democracy is more than just one thing. It isn't just voting rights. It isn't just campaign finance. It is about how the core institutions of the nation we live in, of American democracy, either serve the people or don't serve the people. And for a huge portion of our history, they largely didn't. And so we see the courts as part of this. The courts have played a big role for better and as frequently for worse in American history in terms of supporting our democracy, supporting our environment. But we certainly can't make progress on these things if there is this extremely powerful branch of government that not only has insulated power because they have lifetime appointments and can meddle in so many things, but in addition to those, polls currently show that liberal grassroots nationwide have higher confidence in the US Supreme Court than conservative grassroots. And that's a really interesting thing considering who is on the court. And I think one of the most important things that we need to do in this judiciary space is to make sure that environmentalists, progressives, and supporters of democracy understand what is happening in our courts, and in addition to what we can do about them. And so that is my passion. It is making sure that people understand these issues and know how to get involved, because wow, do we need people to get involved.
And at the very strong case for getting involved in the federal courts, state courts too, are they also important for protecting our environment and democracy? I see you both nodding. Say more.
Yeah, absolutely. I'll be brief and pass to Anthony here. The state courts are hugely important for both of those things, especially the more the federal courts refuse to protect those things, the more important the state courts become. State courts, one, have a huge role in our environment because there's a huge number of environmental cases that concern specific development, specific projects, specific issues in specific places that don't always make it into the federal courts. And on democracy in particular, the state constitutions, all of them, have a guarantee of the right to vote, and frequently have better protections against gerrymandering than the federal constitution does. And so those state courts are hugely important. And so wonderful that y'all in Maine have a good governor and the ability to appoint rather than elect judges. And I hope you make sure that she knows how important it is to appoint pro-environment, pro-democracy judges to the state courts.
Anthony, you want to add anything about state courts? We've got
Sure.
just about 1 minute.
Yeah, all I'll say is that in the climate space, a lot of the activity that's happening nowadays is at the state and local level because of the inaction at the federal level, and all of that is going to be likely challenged or at least come up in state court proceedings, and in particular, some of the more aggressive climate litigation is happening at the state level. In places like California and Maryland and Hawaii, and those are things to watch, and those are all happening in state court. So there's a lot of important things going on in state court. We can't ignore that.
Yes, this balance of what's happening at the state level, what's happening at the federal level. We're actually going to talk a little bit about this next week when we recap the state legislative session, which is wrapping up now. Thank you so much, Anthony. Thank you, Doug. Thanks to all of you for joining us today. I really do love our judiciary-focused lunch and learns because I learn so much and find, frankly, so few places for this kind of conversation. So thank you all for being part of it with us. Today, you will get a follow-up email later this afternoon with the link to the recording and a reminder to stay tuned because elections matter. I think you're probably getting that, but they matter for the judiciary too. So if you care about the shape of our courts, stay tuned for ways to get involved in our elections. Doug gave us a little bit of a hint there about one of the elections that's coming up this fall. And we'll talk more about that next time. In the meantime, have a wonderful, wonderful weekend, and I hope to see you all next week for the recap of the legislative session. Thanks so much.
Thanks, everyone. Thank you, Kathleen.